Today's lecture will be on legal and ethical issues of nursing. Today we're going to be describing the rights of the client in a psychiatric setting, looking at legal and ethical issues related to seclusion and restraints, looking at components of malpractice, looking at ethical issues in the practice of psychiatric nursing, understanding what the meaning of standard of care is, and then looking at different types of torts in the mental health setting. Some things that we have to take in mind is that when it comes to hospitalization, it can be traumatic for that patient, or it can be supportive for them depending on what type of institution they are in, the attitudes of their families and friends, how we respond as staff, and then again, whether or not the admission is voluntary or involuntary. And so we're going to be discussing those two major types of admission. And again, those are voluntary and involuntary. With voluntary admission, a person is willingly agreeing to receive treatment and abide by the rules of the hospital. They are seeking help based on their own personal decision, the advice of their family, or due to advice from a health professional. They acknowledge that they have a problem, whether it be in just living their everyday life, but they're also acknowledging that they need to seek help with coping and will probably actively participate in finding those solutions. While that person is admitted, that patient retains all their civil rights. They may leave AMA at any time, and they may refuse all or any parts of their treatment during this process. Now, one of the things to understand is within some of the hospitals, patients, when they're requesting that AMA, have to do it in writing to the facility. That patient must understand the need for the treatment and be willing to be admitted. Underage patients 16 and under, they need a guardian. Between 16 to 19, they can seek admission independently or on application through an agency. With these civil rights, we need to understand that with West Virginia law, if a person requests AMA and the doctor feels as though there's more going on here than that actually meets the eye, then the facility, the doctor, has a opportunity to reassess that patient before actually letting them leave against medical advice. If on determination they determine that this person may be a harm to themselves or others, there are routes that can be taken to turn that voluntary admission into an involuntary commitment. There are always ethical challenges, whether it be the patient's competency, whether or not they give informed consent, or that type of commitment that they have. But we'll talk about that a little bit further. However, just remember that with competencies, that ability of the person to be able to understand and appreciate why they need to be treated and the type of treatment that they're receiving. With informed consent, they are able to understand the cost for themselves and that benefit of that treatment, and are reasonable with that treatment. They can definitely understand. With voluntary, again, they're willing to enter and participate. With involuntary, it is mandated without consent, but more with a court order to be inpatient or outpatient. Although it's an involuntary commitment, these patients still have the right to treatment, and they still have the right to refuse medication unless it is, again, revolves around them being a danger to themselves or others. Although I talked about this on the previous slide, we're going to talk about involuntary admission, or sometimes when it's temporary. And this means the patient really did not request that they be hospitalized or really opposed to it. It is really without the consent of the patient. However, again, as we talked about laws, if that patient's a danger to themselves or others, if at that time they are mentally ill and in need of treatment, or they're unable to provide for their own basic needs, then an individual can have an involuntary admission. Long-term involuntary admission requires either medical certification, a court order or judicial review, and administrative action. Again, thinking of involuntary admissions, you need to be thinking about what type of individual might be an involuntary admission. Again, we lean back to individuals who are harming themselves and others. And remember, when we're thinking about Maslow's hierarchy, number one, physiological, we're also taking care of their safety. And so that's what makes being able to institute an involuntary admission necessary. We mentioned previous long-term hospitalization. With long-term hospitalization, it's an opportunity for patients to receive care indefinitely or until they're ready for discharge. And even though these patients might be considered committed, these patients still have a right to consult a lawyer when they want to request a hearing to determine whether or not they still meet the requirements to be there. And special consideration is given to individuals, especially if their hospitalization is a result of a crime. When we're thinking about individuals that might give us that gut feeling that we need to be concerned, there are some predictors that kind of let us know that these individuals may have the potential to cause harm or be dangerous. Most mentally ill patients, we want to make sure that we say this, are not violent. However, there are some predictors, as I mentioned before, such as previous violent behavior or a previous or past history of psychosis. If they're non-compliant with their medication, if they are engaging in substance abuse, if they have antisocial personality disorder, or have a lack of insight into the need for treatment, or if the effectiveness of the treatment. So who might be a candidate when we're talking about involuntary hospitalization? These individuals are individuals who may not be able to determine that violence is too much. They might be a potential threat. We have to be thinking about how does what they did compare to the actions of someone who's not mentally ill. So remember that patients at any given time can go from a voluntary to an involuntary. So we need to be making sure that we're always assessing things that patients are saying to us to determine whether or not we need to consider their movement from a voluntary to an involuntary, such as if a patient says, I'm going to make someone pay, then the first response on the nurse is going to be thinking, I need to seek further information into this statement to determine whether or not that person is now, who was voluntary, is in a position to be a harm to themselves or others, and may need an involuntary commitment to protect themselves and other individuals. When discharging someone from a voluntary admission, patients at that moment are ready to leave. Patients can be discharged by staff when they've reached the maximum benefit of any treatment that they have. So if a person, and I want to keep that in perspective, if they voluntarily admitted themselves because they knew they needed help and they are not a harm to themselves or others, they can leave when they're ready. There are times, though, when the treatment that we have reaches its maximum benefit. And even though the patient may feel like they're not ready because they don't present themselves or harm to themselves or others, then they're either referred to outpatient treatment, they could be referred to another doctor, or discharged back to their least restrictive environment, which is home. Voluntary patients may request a discharge. Most states require that in a written notice, as we talked about earlier. And that's more of an AMA. So if that person comes, they're admitted, but the doctor feels like they still need medical treatment, they want them to stay one more day, but they're not a harm to themselves or others, Then they present this document in written format requesting their release. And then the document, which includes their mental status, the reason for wanting to leave, the risk, understating that they understand the risk of leaving, receive their follow-up care instructions, how their conversations with others, and then what their destination and transportation arrangements is going to be made. All that information is documented and placed into the patient's chart. Let me make sure I'm not missing anything. No, I think that's it. So earlier we talked about in the beginning of the semester about patients receiving treatment in the community because it's the least restrictive setting. Well, just like those settings, when it comes to commitments, patients can have an outpatient commitment. So that consists of a court-ordered community treatment or outpatient treatment in which the patient is ordered to do a specific treatment with a specific clinician. So in order to access these services, they have to participate in a treatment or they face a negative outcome or alternative if they fail to participate. Majority of the time, the agency or that is used has a type of goods or services, which means that their treatment has to be effective for that individual. An example of an outpatient commitment was when Lindsay Lohan was ordered to drunk driving and alcohol treatment after she was arrested. So when we're thinking about patients' rights, we need to make sure that upon their admission that they receive a copy of those Bill of Rights, be able to read them, and if not, to be able to have them explained to them. When we're thinking about how Bill of Rights came about, even within the U.S., several things had to be taken into consideration. We kind of mentioned these before, but we need to be thinking in our minds, how well are our patients informed? Do they understand the information? That's competency. Does the patient, do patients exercise their rights? And what happens if they exercise their rights? When you look inside of your textbook on page 31, box 4.1, there's information on patients' Bill of Rights and persons receiving mental health services. I suggest that you guys read over that and just remember that patients' rights are protected and promoted by nursing acting as their advocates. So how many more times can I talk about competency, informed consent, least restrictive environment, and voluntary and involuntary commitments or treatment? So just to go into a little bit more, on page 32, 33 of your book, it talks about competency. Again, it's that person's ability to express their choices, to comprehend the meaning of the information involved in that treatment. And so when expressing their choices, I'm going to go back, that patient should be able to repeat what they've heard with a clear understanding of that information and be able to paraphrase it. They should be able to next appreciate the situation that they're in, the consequences and understanding those specifics, including the disorder itself, the need for treatment, the reason for treatment, and those outcomes. And then be able to engage in a logical thought process that allows them to look at the risks, look at the benefits, and then make a logical decision or conclusion that this is the choice of treatment for them. So with informed consent, it first requires that the patient be given adequate information so that they can make a good decision and to participate in that decision-making process. Their primary care provider must inform the patient in a way that an average reasonable person should be able to understand and make an educated decision about their intervention. And then the patient must be competent to give consent. So their mental illness can't compromise their ability to make decisions. So your role as a nurse is making sure that they receive this written informed consent document, that the patient is educated about whatever the treatment or procedure is, and that they make sure that the consent has been attained before that treatment is given. So a question that you might see might be, tell me why the treatment team wants you to have this treatment. If the client's reason for engaging in treatment is related to other other desires, such as their family or their spouse, then we have the obligation as the nurse, as the highest priority, to evaluate whether or not that patient is capable of giving informed consent. So, if the patient says something like, I like my doctor, so I'll do whatever he wants, that statement alone says, you know what, we need to go back. Does this person have the ability to make an informed consent? An informed consent has to be because I see the benefit or need of this treatment. So just keep that in mind. There are times when the rules for releasing information without consent is broken. These exceptions include when there's an emergency and it's in the best interest of the patient, if it's court ordered, if there's a commitment proceeding or criminal proceeding, or if you're acting in an effort to protect a third person, or third party. So maybe your patient reports having homicidal ideations towards someone that they actually have access to, um, or may not have access to for that matter, but their ability to carry out that plan can be real. Then in that moment, that person may need to be notified. Child custody disputes. It is the law, regardless, that we have to report this information. Any reports that's required by the state law, and again, child or client or elderly abuse proceedings, and I'm going to say child and elderly abuse proceedings. Patients have the right to refuse any treatment, and they should not be forcibly medicated except in situations where the patient is actively violent to self or others, and all least restrictive measurements have been taken and are unsuccessful. The patient's behavior needs to be clearly documented and any interventions recorded. Patients also need to be reminded, or we need to be aware as nurses, that a patient's failure to comply with the treatment could result in a revocation of their probation or even include jail time. An example we have here is when Gabby Gifford, the shooter, which was Jared Logner, he was forced to take antipsychotic medications in order to prepare him for court. So that's just one example. So in discussing forcing medications, there must be some justification for coerced treatment. Again, trying everything first. Once we've done all that, then we may have to visit coercing someone into taking medication. If that patient is a harm to themselves or dangerous to themselves or others, if there's a reasonable chance of this treatment benefiting the patient, or if they're judged to be incompetent. Now, even if these conditions are met, patients should be still informed regarding what's going to be done, the reason why it's going to be done, and what's the effect. So, I have medication, I have a patient, they're acting out, they're being violent, they may be scratching, cutting themselves, and swinging at staff, and the doctor has asked us what interventions have we done. We've tried talking with them in a calm manner. We've tried relaxation. We've tried distractions. And none of these are effective. The patient is now harming themselves. The doctor orders that the medication receive an IM injection of a B52 into their muscular area. Okay. The way this sounds is good afternoon. My name is Lisa. Unfortunately, because right now you've been deemed a harm to yourself or others, the doctor has ordered you 50 milligrams of Benadryl, 5 milligrams of Haldol, and 2 milligrams of Ativan to be injected into your muscle. And this medicine is going to help you relax. Now, you might start to feel a little bit drowsy, so I'm going to need you to stay kind of putting low to the ground or stay in bed, and we're going to be with you throughout this and until you can get back to a calm basis. And that's kind of how that is. Now, if the patient is competent or nonviolent, you can't force that treatment. And other ethical issues come into play when clients are generally sicker if they're non-compliant. Patients' right to least restrictive setting. That is the big goal and aim since the process of deinstitutionalization, is helping patients or preserving patients' autonomy, which is that right that they have to engage in and decide for themselves how they're going to live and engage in their activities of daily living. So the goal is, one, evaluating what those needs are and maintaining the greatest amount of personal freedom, autonomy, dignity, integrity, whether it be in the hospital or in the community. And this requires patients' progress to be monitored. There needs to be a treatment plan, and that is also altered based on that patient's current condition. So we need to always be asking ourselves, is there a least restrictive way to achieve the goal of safety for our patients? Some issues related to restrictiveness includes steps that we might take that include seclusion and restraints. And if you look on page 33, your book talks about this a little bit more. But again, like anything else that we do, we need to make sure that there is a verifiable documented reason that's justified for this patient to receive this treatment. This decision can be either made by court, a designated decision-making person or persons, and this can include you as a nurse along with your treatment team. Examples that we might think of is when you have a suicidal patient who may not that's not permitted to have their belt, their shoelaces, or scissors because she or he may use them to engage in self-harm. Or if a client who is aggressive after having a visitor, that visitor may be restricted for a period of time. Or when a client makes a threatening phone call to others outside the hospital, they may have supervised phone calls until their conditions improve. So, thinking about all of that, we need to make sure that we're asking ourselves the questions: how can we assure that whatever decision we're choosing to use to create restrictions for our patients based on undesirable behavior, we need to be looking at, is it legally correct when we're choosing that intervention? And then we need to make sure, again, that we're documenting what those interventions are, documenting what led up to that patient needing to be put into seclusion or restraints, or what other alternatives were used, what was their behavior while they were being secluded or restrained, what interventions were going on, and after we chose those interventions, what follow-up evaluation did we do? Did we do a reassessment and then then was able to release that restriction from that individual? Release of information requires that we maintain, again, our patient confidentiality. Now, we said there are some times that we have to release information when it's an emergency, but when those things aren't the case, then we need to remember that each patient has the right to determine how their personal information is being released. And a lot of the times on admission, we have them sign something stating what that is. Written consent makes clear what that consent is going to be, if something should arise, who can have that information, and then making sure that it's a part of their medical record or their EMR. it should be um, used as evaluating how accurately and completely it portrays the patient's behavioral status at the time it was written. So again, making sure that when at the time when that patient was admitted, if it was voluntary, making sure that um, the information is correct. Or what if you have somebody who came in involuntarily and they filled out the document but weren't in a position? So we just kind of evaluate those things on a case by case basis. A lot of the times on many of the units, they have a right to privacy, and so they give each patient an opportunity to create for themselves a code word or password that determines who we release that information to, and allows us to verify that that person has a right to information. So the patient is the one who presents that password or code word to individuals that they don't mind us giving information to them and what that information pertains to. When looking at access to health records, most organizations keep psychiatric records separate because they're considered to be sensitive material. So if a patient requests access to their records, we want to explore the reason for their request, prepare the patient for the review of those records, be there to answer any questions that they may have, and be sure not to release material that may come from another source. One of the things that I found beneficial is that if a patient um, asks for the records, never give them the original, just in case their mental status is causes them to be destructive. That way, they're only destroying the copy and not the original. Realize that even though patients have a right to their health records, their actual physical records, any treatment that they have, these things belong to the facility or the therapist. It's property of theirs. For court appearances, remember that the patient records can be brought into court along with the contents um, in those reports for lawsuit matters. Incompetence is a legal term without precise medical meaning. To prove incompetence, it must be proven that a person has a mental disorder and that the disorder causes a defect in that person's judgment. It makes them incapable of handling personal affairs, and therefore a legal guardian is appointed to them. So questions that you want to keep in mind is, what is the ethical issues involving the incompetent client? And the answer is their inability to vote, marry, drive, or even make contracts. Other ethical considerations include paternalism or maternalism. Now, on page 54 in your textbook, it talks about how doctors sometimes um, use this as a way of making decisions that they think would be best for the individual. So deciding what's best for another person without consideration of a person's thoughts, feelings, or preferences can happen. It's that feeling like I'm your mother, I'm your father, I know what's best for you kind of thing in that aspect. Knowing what's good for the patient. It's for the patient's own good. It's done even though the patient may disagree with that action. But it also results in that patient feeling like they are a child, or that it interferes with their freedom to be able to make choices or act in their behalf. So we have to ask ourselves, who gets the greatest benefit from the intervention that we're going to do? Is it the staff or is it the patient? In chapter 6 of your book, we start talking about the ethical part of being a nurse. That's covered in chapters 50, pages 55 to 64. So there are some concepts that we think about, and with ethics, we're thinking about that study of philosophical beliefs about what is considered to be right and wrong in today's society. Bioethics looks at the relation um, between ethical dilemmas surrounding healthcare, and in ethical dilemmas or conflicts between two or more courses of action, each with favorable and unfavorable consequences. And there's some basic principles, and I think this is where we're going to focus some of our attention on. But when it comes to ethical theories, they create principles to help us decide that difference between what's right and wrong. A lot of the times, you'll see utilitarianism or deontology being used. And with utilitarianism, you're looking at what is the greatest good for the greatest number. With deontology, it's based on whether or not the action is morally right and has no regard for the results or consequences. So, um, when it comes to this, we're looking at autonomy, benevolence, non-benevolence, justice, veracity, and fidelity. And all of these you need to look over and understand. So we have these there as principles: that benevolence, that duty to promote good; autonomy, respecting the right of others to make their own decisions; justice, distribute resources or care equally; fidelity, the obligation to honor commitments and contracts; veracity is one's duty to always communicate truthfully; and non-benevolence is the requirement to do no harm to others intentionally or unintentionally. And that's where we talk about more about this deontology, which is based on whether or not an action is morally right with no regards to the results or consequences. And these principles come into play here. So, an example of an ethical dilemma they may result, and I have this down in your notes, so you guys don't really have to like write this. But if a client, in a situation where a client refuses medication and treatment and is allowed to do so on the basis of autonomy, being the right to make decisions, that's what's allowed to happen. However, if the client begins to present themselves as a harm to self or others, now we have the principle where we have the requirement to do no harm. So this puts the patient at risk. So to protect the client and others, the client may be involuntarily committed. Now, you're going to have a lot of people who may have different ideas of what's supposed to happen. Some may argue that this violates the patient's right to autonomy. And other examples, especially with the utilitarian theory, the greatest good, which is involuntary commitment, overrides their right to refuse treatment. And so a lot of the times what you'll see is that there ends up being dilemmas related to a person's right to make that determine what's good for themselves over the concern for the public. And you'll see that a lot, which is why we as nurses have that really strong obligation to do our best to advocate for our patients and making sure that when we're making decisions, the decisions are in line with what's best for the patient, not thinking about what's best for us or what's best for the community. In our previous slides, we talked about the exceptions to confidentiality. And one of them was a duty to warn or protect third parties and report possible abuse, whether it be child or elderly. So most states recognize that there's a variation and that it obliges the clinician to take into consideration the following three things: assess the threat of violence to another. Is this threat reasonable? Is it possible? What's the plan? Are they capable of carrying it out? Identify the person being threatened. Is the personal thing being threatened identified? Do we know who the person is? Do we have specifics? Are there details? And then implement some affirmative or preventive act. The courts extend the scope of duty to protect property as well as individuals or persons. So we need to make sure that we're documenting the threat and the measures taken inside that client's records just in case. A question to keep in mind is, how does this reconcile ethically with confidentiality? Just food for thought. Then your book doesn't go into detail as much as it always has, but I have this information, and as long as it's being covered into your slide, then we're doing good. So when we're thinking about psychiatric nursing and criminal responsibilities, there's something called insanity. And insanity is this defense based on the rationale that people should not be blamed for crimes that they didn't know they were doing, and couldn't help themselves for. So, movement away from the defense, we have not guilty by reason of insanity, or NGBI, to the more recent guilty but mentally ill. So, over time, we've changed. However, those two, sometimes you will see them used synonymously. But that GBMI, guilty but mentally ill, results usually in an involuntary commitment of the individual. Many of our states no longer recognize the insanity defense. However, a criteria to determining this is asking, did the person know the act was wrong? Was there no premeditation or impulse driven associated with the event, and the lack of the ability to appreciate long-term effects of the act? There are national standards of care and even our institutional policies that require us as nurses to just, it's a standard that we're just held high to. It's required of all of us as providers. So, keeping in mind what our role is as nurses, there are times when a tort is involved. It's a civil wrong for which money damages may be collected by the injured party from the responsible party, which is defendant. So, intentional torts can include assault, battery, false imprisonment, invasion of privacy, defamation of character, and you may hear that as slander or libel. Now, unintentional torts include unintended acts against another that produce injury or harm, including negligence and malpractice. Now, I want to take the opportunity to go through a little bit of this. When we're talking about assault, we're talking about actions that cause a person to fear being touched in a way that's offensive, insulting, or physically injurious without consent or authority. Battery is harmful or unwanted contact with a client. In this case, actual harm or injury may not have occurred. So, an example would be touching a patient without consent or unnecessarily restraining the client. False imprisonment is unjustifiable detention of a client, such as restraints or seclusion. Providing liability involves three elements. Pay attention. Make sure I say this. Providing liability involves three elements. The act was willful and voluntary on the part of the nurse. The nurse intended to bring about consequences or injury to the person, or the act was a substantial factor in causing injury or consequences. So, why is this important to us? And throughout our job, there are a lot of times in which we come in contact with our patients. We are held to the standard of care and whatever our institutional policies are. However, there are times when patients perceive our actions to be wrong. There are times when evidence supports that either knowingly or unknowingly, we as nurses do something that ends up having a direct effect on our patient. Or maybe it may not have caused injury, but still was undesired by the patient. And so we always have to be cautious about these things. However, when we're thinking about liability, again, I want you guys to remember those things, and it's in the notes here. From proving liability involves three elements. You need to keep those in mind. Now, on the next slide, we'll talk a little bit about negligence and malpractice. But to understand that negligence is unintentional cause of harm by failing to do what a reasonable and prudent person would do in a similar situation. Malpractice is a type of negligence that refers specifically to professionals such as nurses and physicians for four reasons. Keep these in mind. Duty, breach of duty, injury, and causation. Most of the claims that are filed usually fall under the law of negligence, that civil wrong for which the injured party is entitled to compensation. Negligence is, what am I trying to say? When a, when someone can prove that we as nurses had a legal duty of caring for a patient, that the duty was performed negligently, that damages were suffered to our patient as a result that cause a fact, that no one or anything else was involved in that damage, and that damages were substantial, then those are all the criteria that meet negligence. And you need to make sure that you put this into your memory, because we're going to talk about that. With malpractice, it's a failure of someone to provide proper, competent care to a patient, and as a result, there's harm to that patient, and as a result, because of the different perceptions of other individuals, the maybe the intentional or the non-intentional way in which we perform our care that has a direct effect on our patients, because we have no control over that, their perceptions, and anything is possible. That's why it's important that as nurses, we make sure that we carry a malpractice insurance. Another thing to keep in mind from that previous slide is that a failure to report an incident is not considered negligence. Okay, so now testimonial privileges. Nurses, we're not excluded. There's no confidentiality. If we're being called to court, we have to show. So that legal term of being privileged applies only in court-related proceedings. So communications between husband and wife, attorney and client, clergy and church members, that's the only time that happens. The right to reveal information belongs to the person who spoke. The listener cannot disclose information unless given permission. Patient could sue listener for disclosing privileged information. Only communications of a professional nature are protected. So a third person presents during communication between a therapist and patient may be required to testify and are not included in privilege. So in final, I want to make sure that you guys take the opportunity to look at page 39. It talks about steps to avoid liability. This is just really good information as far as integrating this into your nursing practice. Please be sure to review your key points. Another thing I want you to keep in mind is just remember that as nurses, we all have some type of idea of what we believe is right or wrong, or what we believe is good or bad. And that we have values just like everyone else. But when we decide that we're going to join this nursing profession, we assume a responsibility or duty to the patients that we care for and their family, to not only protect their rights, but to also advocate for them and to act in their best interests, even when that conflicts with our own personal values and beliefs. We're obligated to engage in self-awareness and to make sure that we're not allowing our personal beliefs or values to overshadow that of our patients. If conflict cannot be resolved within ourselves, then we need to make sure that we're talking with a colleague to find someone that can better meet the needs of our patients. And if I haven't already implored you to do so, please make sure that you review the questions located in the PowerPoint for legal items for review. This is the end of our lecture, and have a good day.